Hi guys, it's Kathy. I hope you're doing well. Sorry, last night was my Christmas with my closest, my kids and my niece and my nephew. We wait an extra month to do our Christmas, so we have enough resources. They're our closest, so it's easier for us. And look at this. I got a great big hoodie, the great big pocket. But wait, one person got me this. Another person got me another one, the same thing. They didn't know. But yeah, I'm sorry I'm late. It was all the trash cans last night. I have a new judge from Colorado that I really like. And this clip is 3 cases. The first one is, serious. We're introducing her. No, psoriasis. I have psoriasis. And it got under the eyelid. So every time I blink right now, it's scratching my eye. I thought it would be chill by today, and it just isn't. So I used to wear sunglasses for my streams whenever it flared up. But unfortunately, I don't know where they are right now. So I'm not going to have the camera on a lot. But that's right. I'm going to be chilling here in my hoodie or whatever this is called. I think it's called an hoodie, right? The inside is sinfully soft. Sinfully soft. Okay. The first clip, heavy. A bit, not too heavy, just heavy. And then the next 2 clips are great, and then we're going to go on to 2 other judges. Here we go.
The name victim by WebEx.
Yes, Your Honor. She did indicate to me that she was going to be present. She may be the phone number.
I know I can hire. Phone number ending in 16. Is that Miss McIntyre?
Yes, Your Honor.
All right. Good morning to you as well.
Good
Mr.
morning.
Mr. Gagarin appears on Mr. Campbell's behalf. He is in custody today. We are set for an initial arraignment after being bound over November 24th. In terms of the case, where do we stand, Mr. Gagarin?
Your Honor, in terms of the case, Mr. Campbell would waive any further reading and advisement, enter a not guilty plea to the charges. I do want to note for the court that the county court bound over count 1, but not as a class 3 felony, rather as a class 4 felony. I think it's probably best if we have a modified complaint at some point so that there's no confusion about that. I know Ms. McIntyre filed a motion to address the protection order, and the language of that motion seemed to imply she also wanted to address bond. We also filed a notice of bond. With respect to setting, I will tell the court, I think for setting, we can set a pretrial conference. And if we want to set trial dates, we can, but it's kind of where we're at.
All right. Let me start with Ms. McIntyre. Well, Mr. Brown, do you have any record related to the protection order request before I inquire of Ms. McIntyre directly?
We're going to oppose a modification, but I think it is appropriate to hear from Ms. McIntyre. And she also did file a substantive motion for the court to review containing the specific modification request, which I believe was to participate in counseling with Mr. Campbell.
Are you talking about the document filed on January 13th?
Yes.
Okay, great. I have seen that. Ms. McIntyre, so my understanding from the pleading that I got is that you are requesting to modify the mandatory protection order that's in effect in this case. Is that correct?
Yes, Your Honor.
All right, will you outline for me what it is you are requesting, please?
I would like Mr. Campbell to have free access to each other so that we can go to counseling and resume our life.
All right, and have you had an opportunity to speak to a victim witness advocate with the Gilpin Jeffco District Attorney's Office?
Yes, Your Honor, I did a safety plan with her.
And so if I'm understanding you correctly, you're asking for unlimited in-person contact. Is that accurate?
Yes, Your Honor.
Right, Mr. Brown?
Your Honor, the reason that people are opposing a modification to allow in-person contact is primarily because I have significant concerns about Ms. McIntyre's safety. The underlying facts of this case is that the defendant from roughly Gilpin County forced the victim to drive with him in her car down through the metro area into Arapahoe County. On the way, there was a ready report from a bystander who said that they observed the defendant bash the victim's head into the dashboard of a car when the victim was in Gilpin County and she was behind the driver's wheel. She was engaged in a conversation with a family member, and the family member heard some form of screaming or alert and also called 911. When the victim got to Arapahoe County, they were at a gas station convenience store. She ran into the gas station convenience store in order to seek safety. At that point, police were summoned, and the defendant had fled and was not able to be located. But to his credit, when he learned that there was a warrant out for his arrest, he did surrender to Gilpin County Sheriff's Office. The defendant, I believe, is currently on parole. He has a 2022 conviction out of El Paso County for a drug felony 2, conspiracy to manufacture. He was sentenced to 4 years Department of Corrections. A 2021 aggravated motor vehicle theft is a class 5 felony. El Paso County, he was sentenced to 6 years Department of Corrections. A 2021 El Paso County conspiracy to possess with intent to distribute, he was sentenced to 6 years Department of Corrections. He has a 2018 El Paso County controlled substance possession. He was sentenced to 1 year Department of Corrections. He has misdemeanor offenses, including a DUI in 2015 and 2020. He has a 2015 El Paso possession of a weapon by a previous offender, a class 5 felony. He was sentenced to 3 years at the Department of Corrections. He has a 2014 El Paso County eluding a class 5 felony. He was sentenced to 3 years Department of Corrections. And he has a 2012 El Paso County attempted robbery as a class 5 felony. And he was sentenced to 3 years in the Department of Corrections. Thank you.
Mr. Gagarin, any position of Mr. Campbell on the request to modify?
Yes, Your Honor. The request to modify the protection order, we would simply, I guess, join the Ms. McIntyre's request, and if the court does not feel that full contact is appropriate, certainly any whatever communication or contact the court deems appropriate, Mr. Campbell would request. With respect to bond, Mr. Brown went through a recitation of his perspective of the facts. I will only state that Ms. McIntyre has repeatedly disavowed much of what she said and what he said previously, both to Mr. Brown as well as to me. And so I think there's certainly a lot of there's significantly contested what actually happened. With respect to the bond, Mr. Campbell acknowledges that he has that history that has been discussed. He acknowledges that he's not a perfect person. I do want to tell the court about a conversation that I had with his boss, because I think it indicates that Mr. Campbell is not the person that is reflected in his criminal history. I talked to a man named Dustin who runs what what is a landscaping company, but they've actually transitioned into doing more running fiber optic cable, other kind of conduit for municipalities. So manual labor, but kind of technical labor that Mr. Campbell was doing. Mr. Campbell's boss relayed to me that he has seen an incredible change in Mr. Campbell in the time that he's been employed, that he would hire him back in a heartbeat. He's by far one of the hardest workers he's ever had. He's incredibly intelligent and capable in his work, doesn't make the same mistake twice. And then he relayed to me a situation where essentially Mr. Campbell and another individual had to be paired to complete a job. And Mr. Campbell does not speak Spanish, and the other individual, Josue, only speaks Spanish. But because of logistics, they had to be paired together on this kind of complex job laying conduit. And Dustin relayed to me how he was concerned about putting Mr. Campbell with Josue because of the language barrier, but also because somebody with Mr. Campbell's kind of history, he was worried how he would react to the frustration that not being able to communicate with his coworker would kind of bring about. And what ended up happening was that Mr. Campbell and his coworker, despite the fact that they were unable to speak to each other at all, completed the job quickly, efficiently, proficiently, but also they dealt with their frustration, and Mr. Campbell dealt with whatever frustration came out of that lack of communication in a way that was productive. It wasn't destructive. They didn't butt heads. They figured out a way to work together despite some.
So Mr. Campbell didn't punch his coworker where he's getting paid to do that work and is supervised. He didn't, lose his temper and punch another man who is probably equal of strength as him. Oh, so I get it. Okay. He's fine, Judge. Completely the same thing as his girlfriend or wife. Completely the same.
Very obvious frustration just because of the situation. And Mr. Campbell's boss relayed to me that he was extremely kind of pleasantly surprised to see somebody that he probably kind of judged prematurely, see Mr. Campbell handle that kind of a situation, handle frustration, handle stress in a way that was professional, in a way that was efficient and got the job done. And ultimately, Mr. Campbell and Josue kind of bonded, even though they can't actually talk to each other. And so I thought that was an interesting anecdote simply because it is very easy to judge Mr. Campbell based on his history. It's probably going to happen to him for the rest of his life. He acknowledges that. He is asking some consideration to look beyond that. When I asked his boss if if he would hire him back, I think I already said this. He would hire him back in an instant. He already talked to his boss, and his boss said to Mr. Campbell's boss's boss said, absolutely no worry, like nothing standing in the way of that. Mr. Campbell has the strong support of his family. He has the strong support of his employer. And he is, I believe, still on parole. I believe until April of this year. However, my understanding is that there is at least some possibility that he could be re-released to parole rather than taken to the Department of Corrections if he is granted a bond that he can post. So with all that said, Your Honor, Mr. Campbell is simply asking for some consideration on the bond. Your Honor, understanding the nature of the allegations, though we're actually here for the first time on the reduced allegations, we'd ask for bond in the nature of $25,000 to $50,000 cash or surety.
Ms. McIntyre, you certainly do not have to address me related to bond, but is there anything you want me to know or consider related to his request to modify the bond?
Yes, ma'am. I would like you to consider the fact that while Aaron was out, he sought help from a physician that diagnosed him with a compulsion, ADHD with compulsion disorder, and wanted him to start a medication regimen.
That checks out. Everybody I know who has ADHD beats the crap out of their partner.
However, when we checked with the jail or whatever, they would be able to administer it to him. So he's waiting to start that. And then along with our individual counseling and couple counseling, I feel really safe, and I'd be thankful to have him home. I'm going through a lot as well, and he a big help to me.
Right, thank you, ma'am. With me a moment. Right, the court has reviewed portions of the affidavit in support of warrantless arrests. The allegations in this case are extremely concerning and alarming in terms of both the allegations of physical violence and verbal threats. The court acknowledges that the minute order reflects that count 1 was bound over on a lesser class 4 felony. And as I understand it, counts 2 and 3 were also bound over. And so the allegations in this case include 3 class 4 felonies. Given the seriousness of the allegations and my concern for Ms. McIntyre's safety, I cannot find that allowing full contact is appropriate at this juncture of the case. I will allow Ms. McIntyre and Mr. Campbell to have electronic communication via text or email, and I will allow them to have contact in the course of therapy if they choose to engage in that. And so the protection order will order, Mr. Camp, the modified order will order that you not harass, molest, intimidate, retaliate against Ms. McIntyre, that you still have to stay away from her home, that you shall not possess, purchase, or control firearms, weapons, or ammunition. We've already discussed relinquishment. That would be required if you post the bond. You cannot possess or consume alcoholic beverages or controlled substances. And then box 9 will read that contact is allowed via text, email, or for marriage or family therapy.
Thank you.
In terms, and so that is boxes 1, 2, 4, 5, 6, 7, 9. In terms of the bond amount for will set or modify bond to $50,000 cash or surety with the conditions that Mr. Campbell comply with the mandatory protection order. No possession of alcohol, drugs, or weapons. Apply for public defender within 24 hours of release from custody. Comply with parole.
$50,000.
And I am also going to do pretrial supervision.
Could you also add, stay away from casinos, please?
What? Wait.
No gaming establishment.
Hold on. Judge didn't even ask a question about that one. No gambling? That's just rude. All right. I'll take the $50,000 bail. That's fine. I thought we never get to see that high of a bail on a TV case. So I'm so pleased. But no gambling. Come on, the crime doesn't fit the punishment.
Any questions for me, Mr. Campbell, about the conditions of your bond?
Your Honor, he's just asking if he's on parole and reporting to parole, does that constitute pretrial services or?
Still report to pretrial. I just want to make sure that you are getting the reminders that we're ensuring that you're compliant with the other portions of your bond.
And then the only other question I had, Your Honor, the court said contact permissible for the purposes of engaging in therapy. Is that allowing in-person contact at the therapist's office or?
Yes,
Okay.
but only there. Otherwise, if they do it virtually, virtual is fine too, obviously, but I would allow in-person contact at a certified therapist's office only.
Does that make sense, man? Okay.
All right, court accepts the not guilty plea, calculates speedy to expire July 17th of 2026. So we have until then to get your case tried, Mr. Campbell. You asked for pretrial only, Mr. Gagarin, or did you want to go ahead and set trial dates?
Your Honor, with the modification to the bond as well as, I would just ask for a pretrial conference and we'll see what the circumstance is at that point.
All right, let's February 13th, 8:30, given his current in custody status, work for everyone?
Fine for the people.
Yes, Your
Can
Honor.
you check with Ms. McIntyre?
Yep, Ms. McIntyre, does February 13th at 8:30 work for you if you wish to be present at his next appearance?
Yes, Your Honor.
All right. You can get a copy of the modified protection order from the district attorney's office, okay, Ms. McIntyre?
Okay, thank you. One thing that I'd like to tell the court or what that I've been trying to contact Bruce Brown regarding, this case between Mr. Campbell and I. We were able to contact once via telephone, but I haven't gotten any responses to my email.
I'm sorry, Ms. McIntyre. I apologize if I have not responded to you, but I'm in court today all day, but I will reach out to you on Tuesday. And assuming your phone number has not changed, I will make a telephone call to you. Does that work?
I appreciate that.
No problem.
Along with that, am I still not allowed to have the discovery?
So I'll have you have a conversation with Mr. Brown and the victim advocate about that, Ms. McIntyre. There are limitations of what they can provide during ongoing and open cases, but have a
Okay.
conversation with either Mr. Brown or the victim advocate, okay?
Yes, Your Honor.
All right. Thank you, Ms. McIntyre. We'll see everybody February 13th, 8:30. Thank you, Mr. Campbell.
Thank you.
That's romantic. They're coming back February 13th. All right.
Ms. Led-
Now, so that was just to show, she doesn't really play around. She's not lenient or soft. She's not as screamy. But she has a huge hammer. Like yesterday, was it yesterday or was it the day before? We had that similar judge, and she was much more judgy and sharp and pointed. This judge is less, but still the same, $50,000 bail.
Better if you
No
want to come on up. You can either use the podium and the microphone there, or Mr. Brown, it looks like Mr. Gagarin's going to move. You can use that table as well.
Is this
This is a domestic relations case. Sorry.
me to move?
You're good.
Okay.
You are good. Thank you so
You're
much. All right. Court calls in the marriage of Ledbetter. This is 25 DR 30004. Set for a status conference this afternoon. Miss Ledbetter appeared.
This is not a domestic relations case, so she was just talking about something else. This is divorce custody.
In person. Mr. Ledbetter appears on WebEx. And we are set for a status conference with the intention of addressing the issue of the appointment of the child legal representative and getting permanent orders reset. I know the parties are set for an upcoming temporary orders hearing with Magistrate Upton on January 28th at 3 p.m. And I also know that there was a recent emergency motion filed by Ms. Ledbetter on January 9th related to the automatic temporary injunction and the children not leaving the state of Colorado, and Magistrate Upton issued an order on January 12th requiring Mr. Ledbetter to return the children to Colorado no later than this upcoming Tuesday, January 20th. So we have a few things to address. The first thing that I wanted to address is the application for the child legal representative. Mr. Ledbetter, your application for court-appointed counsel does not list your household size.
I think when you hear CLR, it's the same as a GAL. All right. Child legal representative is the same as guardian ad litem. I think they're very similar. He took 4 kids to a different state, even though Magistrate Upton told him not to. I can't get Magistrate Upton that I know of, so we wouldn't have seen that.
Obviously, I am aware of the 4 children in this case, but do you have any other individuals in your household other than those 4 children?
I do.
Other children?
No.
Another adult?
Yes.
And does that, let me just see how the wording is, sorry. Is that person dependent on you?
Sorry, Bren,
financially?
I had to make her
No.
small.
All right, so they're independently employed
Yes.
or have income of their own?
Yes.
Okay, so then I think for purposes of the analysis of appointment of the child legal representative, the statute requires the court to consider in a dissolution case, the assets or income of both parties in determining whether the party qualifies. Give me a second, sorry. So I believe that the court is to use a family unit of 6 as if the family were still intact. Bear with me. I think the other issue is that the VA benefits are, sorry. Okay, so by the court's analysis, when I'm looking at the Chief Justice Directive related to state pay for indigency for a child legal representative, for a family of 6, income plus 25% of poverty, the high end is $4,495. I read Mr. Ledbetter's application to indicate that with his VA benefits, which are considered legal income under the statute, he exceeds that threshold of $5,618 would be his total monthly income. And so I do not believe that I can find that the parties qualify for a state paid child legal representative in this case. Given that, my question to you, Mr. Ledbetter, because you are the person that made the request for the CLR, is are you wanting me to consider the appointment of a CLR that would be privately paid?
Yes.
Okay. And by doing so, do you understand that you would likely be ordered to bear the costs of those expenses?
Yes.
Okay. I still believe, based on my previous ruling, that it is in the children's best interest to have a child legal representative appointed to represent the best interests of these children, especially given the recent issues that have occurred. The problem, Mr. Ledbetter, is your proposed CLR does not take private pay appointments. She only does state pay appointments. And so I think that puts us needing to go back to the drawing board for a private pay case. I can certainly reach out to the other CLRs that are approved for this district and see if any of them can take the private pay. Do you want me to do that, or do you want to have an opportunity to propose who I appoint?
I feel like you're good to who you appoint.
Okay. All right. So I will work on identifying a child legal representative that can take a private paid case and issue an order of appointment, ordering Mr. Ledbetter to bear those costs. Given that, I want to ensure that we get that CLR up to speed, and that we set permanent orders on their calendar. And so what I'd like to do is set another status after the temporary orders hearing and have that person appear virtually so that we can select dates for final orders. Does that work with both of you?
Yes.
Yes, ma'am.
Okay. Well, we could do that February 13th at 1 p.m. Does that work?
Yes.
Okay. And I can authorize a virtual appearance, Ms. Ledbetter. You can come in person if you want, but if it's easier to be online, that's fine. The purpose will just be hopefully to have that CLR appear. The two of you, that CLR and me, then can select a date for permanent orders that works on all of our calendars. You do have the temporary orders coming up in front of Magistrate Upton on I just want to confirm, the 28th.
January 28th
At 3 p.m. and that's here in person. Unless it has been addressed otherwise, have you requested to appear virtually, given you being in Illinois, Mr. Ledbetter? Or are you planning on
No,
appearing in person that day?
I'm in Lingo. The attorney, the organization shut their doors on the 31st, and so the attorney moved to another firm. So I'm in the process of retaining her again. It's just that's a new process.
Okay.
That's what she had to do. It put me in a limbo as well too, especially with the situation that happened as well.
Okay.
But yes, that's where I'm at. I will put a motion in for that to do virtual.
Okay. Ms. Ledbetter?
What's the situation that happened?
I'm,
being removed?
yeah, the kids being removed is what I was referencing.
To be returned?
So the court order is that they be returned by Tuesday, is it Tuesday the 20th or Monday the
20th.
Yeah, Tuesday the 20th, Mr. Ledbetter. I'm assuming that you have plans to get them back here by then?
He didn't. He turned in a letter that said that he refuses to bring the kids back, that he already enrolled them in school in Chicago.
I have not received.
I sent a
He sent
motion
it to
in
the
this
county
morning
clerks.
just
It
to
was sent
review the
yesterday.
madras's order. Because I financially cannot do this on the time frame I did, because I funded the road trip there and back both times.
It should have never been removed in the first place. They should have been steady at home until this is over.
Speak, woman, speak. You're right.
I see it now.
Something with a video attached to it or something. Yeah.
Okay.
And I'm unaware what the video even is. I haven't gotten.
I've also not seen that. We can't receive video evidence.
No, I'm sending a USB to both parties. I do understand. I'm like I said, I'm in Lingo, so I'm being notified and doing self-help at this time.
All right. Give me 1 second.
May I speak, Your Honor?
Yeah, go ahead.
Yes.
Yeah, go ahead. Sorry.
From the day this divorce started, I haven't received any of his financials. A lot of the things that you have required and asked have not been to me have not been fulfilled on his end. I have followed everything according to what you have asked and how you have asked us to do things, pulling the kids out of their home and their school and their academics is totally insane to me. It's going to mess up their whole entire their, their everyday lives. Um, only bringing all four and only returning two, but locking two in the vehicle and not even letting me talk to my children or hug them or even ask them if this is what they wanted was the hardest thing I have ever been through in my whole entire life. I just want for things to be done correctly. The next thing that was supposed to be motioned was him requesting for us to have not a mediator, but I guess an investigator to talk to the children. I'm totally fine with that.
That's what I was just addressing with this.
Yeah.
And so I just want to be clear that part of the delay there has been, I needed to make a determination about qualification.
Yeah.
And so I'm sorry for the delay there, but
No, that's fine because I was already looking into resources to get help because my income is not at all his. And I was very nervous about having to come up with a couple $1,000s for that investigator. So if he's requesting it, I'm glad that because I can't afford that.
Yeah, I think the difficult situation that I am in is this. There, in every divorce case, is an automatic temporary injunction that issues, that orders that children not leave the state of Colorado without permission of the court or permission of the other party.
I did not give permission at all.
I know. And so the facts and circumstances when Ms. Ledbetter first brought them up in terms
That one little I know. That one little I know just told us everything we need to hear.
of the allegations that Mr. Ledbetter had brought them to Illinois over winter break was one issue, because that was a temporary, as I understood it, Christmas or holiday trip.
I didn't agree.
It is clear to the court at this point that the temporary injunction preventing the kids from being removed from the state of Colorado while the case was pending without the court's permission has been violated.
Yes.
That is why Magistrate Upton ordered the children to be returned to Colorado by Tuesday. I am concerned about how this has occurred and the effects and impact on the children. First of all, on separating the four children into the two different homes. And secondly, the ways in which this has the potential to pit the children against one parent or the other, or ask them to take sides, or put them in the middle of the parties' disagreement. And it's wholly, frankly, inappropriate. That is the purpose of the temporary injunction. Also, there has been no request filed requesting to have the children permanently, I guess, relocated out of the state. Obviously, this is the ultimate issue of the parenting time of the children and where they live and who is the primary residential custodian and which schools they're enrolled in, whether it's Colorado or Illinois, is going to require a contested hearing. I understand that the parties are obviously in disagreement. That is not what we are set for today. I am also concerned about the idea or prospect of these kids having to bounce back and forth, given what just occurred over the Christmas or the winter break, I should be saying.
Your Honor, can I say something?
Go ahead,
know
Mr. Ledbetter.
I did agree to all the things. I brought all four kids back. Two of the kids did not want to get out of the vehicle, and I told them the only thing I could tell them is I can't force you out of the vehicle. And Michael and Jeremiah did want to talk to their mom, and Michael's the one that recorded the situation. That's why I didn't know how to submit it. That's why I'm sending USBs. because of the things that were being said. And I drove 15 hours, and so I didn't say anything.
So you
I
had our
wasn't there.
son
So the
record you?
problem from my perspective is Mr. Ledbetter.
Yep, he just said that. The USBs he's submitting is he is having his children record their mother so that he could submit it to court.
Is that there was no court authorizing you to relocate them to Illinois. And that
Okay.
is a problem. And so from my perspective, you did have the ability to tell them that they had to get out of the car because that is the state of the legal orders that you had before them. I am concerned though by what damage is going to be ongoing by bouncing them back and forth. And so what I'm contemplating, let me just ask this, Ms. Ledbetter, if I enter an order that requires Mr. Ledbetter to facilitate you having a conversation or phone call with Jeremiah and Michael before the temporary orders hearing, such that this issue of their temporary kind of where they're living and going to school can be addressed in that hearing with the magistrate on the 28th, are you amenable to that? Rather than requiring them to come back and then deciding on a temporary basis.
I think my children are safer with me. I have not made conflict with him. I've done everything that you have asked me to do accordingly. And I think my kids need to be right here where they've been and in school and back to their regular schedules. I'm afraid as well that there's manipulation going on in the other side and that, to have my son recording, that's a little crazy to get the kiddos involved. He did not let them out of the car and they did not let me know that they wanted to be there. Jeremiah is 10 years old. He does not need to be in the middle of this. He needs to be at school, happy, going to his band practice and doing his activities that keep him busy, not just torn away from his mother and his other two siblings. Michael has wrestling and there's all kinds of things that Michael has in school that he needs to take care of. This has put a toll on everyone, even my other two siblings. Separating the children is not something I ever wanted, Your Honor.
In your knowledge, has Michael and Jeremiah, have they had contact with the younger two children since the time they went back to
Michael
Illinois?
erased himself off of our family group chat. He will barely even respond. And I have no access to Jeremiah because Jeremiah doesn't have a phone. And every time I do try to text this man, it always ends up into a hardcore argument about how worthless I am when I have been the sole provider of these children from the day they came out of my body. And I have not received not one bit of child support since this divorce has been finalized or since he has filed for divorce. He will send the kids money through their cash apps, $20 here and there, nothing this way. Super, it makes no sense for the other two to be over there when I have been their sole provider from day one. Also, Michael is his adoption child.
I'm sorry, I don't know what you mean by that.
Like he adopted Michael. Michael is not his biological
That doesn't matter.
son.
That doesn't matter, lady. Move on.
Mr. Ledbetter, any additional record related to the existing order that you return the children by Tuesday?
I motion to extend it because I can't financially do it right now, on Your Honor, with everything that I just did.
Bullshit.
And I've never have stopped her from texting or calling. I will send evidence of the text messages. The last call Jeremiah did give her a voicemail. She hasn't picked up on it. Michael did say he talks to Jeremiah and James, or Jeremiah and Avery.
James and Avery,
but they're okay. They're doing okay. They're passing is what I'm worried about. When I got them enrolled, I didn't realize that Michael and Jeremiah are not at the best grades.
So what day did they start school in Illinois?
They started school 2 days ago.
What day were they due back in public school here, Ms. Ledbetter?
He took them
No, but when were they supposed to start? Had they resumed here?
The 6th.
last Monday.
The 6th. Yeah, I mean, my concern is how much school they have missed
Yeah.
here.
And I've already talked to the school and the counselors and stuff to help them with their grades. But
The counselor did call me about Jeremiah.
Yeah, I mean, this is the problem is this is
I know
why
I'm gonna
these
pick-
decisions can't be made unilaterally because there was no hearing for a neutral party to determine the best interest of the children. I can't find that, oh, let me back up. First of all, I don't know that there is authority to request a review of magistrate order on an emergency issue. No consent is needed. Even if there is, in my review of the magistrate's order, there is no indication that there is clear error in her factual findings and in her application of the law based on the temporary injunction that went into place when this case filed that was ordered for the children to do not take the children in this case out of the state without permission from the court or the other party. And based on the fact that these 4 children sibling group is now separated, and based on the fact that they should be in school, I am affirming and adopting the magistrate's order that the children be returned by Tuesday. We got to find a way to do it. I have to minimize disruption to them. I understand that there is likely going to be a long-term request, Mr. Ledbetter, that they live with you or be enrolled in school with you. That is something we can address through a full evidentiary and contested hearing after the child legal representative is on board and has an opportunity to weigh in. But the interim should be that the status quo is maintained. And the status quo in this case is that the children were attending Gilpin or Nutterland public schools and living together, the 4 of them here in Gilpin County. And so that order is maintained. You all are set for a temporary orders hearing to address other temporary orders in terms of parenting time and decision-making until we can get set for permanent orders with Magistrate Upton on January 28th at 3 p.m. I will authorize virtual for that appearance, Mr. Ledbetter, because I want you to prioritize getting the kids back pursuant to the order. And so if you need to use the money to get them back and then appear virtually for temporary orders, that's fine. And then Magistrate Upton will have the authority to enter temporary orders related to temporary parenting time decision-making, what's going to happen with the kids on a temporary basis come the January 28th hearing. We have the next status with me on February 13th, 1 p.m. virtually. That will be to get a permanent orders hearing set and ensure that I've been able to find the CLR to appoint. Any questions, Ms. Ledbetter?
No, ma'am. Also, this had to have been pre-planned through Michael, my son.
I just can't take contested evidence today, Ms. Ledbetter. I can't because that's not what we were set for. I'm sorry, I've got a full docket that I have to get back to, but certainly that is what we can consider when we're considering permanent orders, okay?
I was just gonna mention, he took all their clothes.
Okay, so make sure they return with adequate belongings to, function and live, Mr. Ledbetter. Anything else you need from me today?
Look, he's shaking his head no. He's not going to.
No.
All right, we'll see everybody.
He is absolutely not going to return these kids by Tuesday. He is just not.
See everybody virtually on February 13th. You'll see Magistrate Upton before that.
Thank you.
I'll want
Thank
that
you,
back
Your Honor.
so I can remember to do this. People versus Jonathan Baumhover, 25 CR 54.
Bruce Brown for the people.
So they were the
Good
Ledbetters, and this is the Bonhoeffer.
Afternoon.
Your Honor, we are VRA compliant on this case. I know that the victim had wanted to appear, but there was some conflict with the her work schedule, but I'm in a position to articulate the request on her behalf.
All right, so we are here. Ms. Mason filed a written request to modify the criminal protection order on December 30th. The court, that written request asks the protection order to be converted back to no contact. Except for via, it sounds like talking parents or at, it says official therapy appointments.
Your Honor, I did have a communication relayed to me afterwards that Ms. Mason wanted no contact whatsoever. So I haven't necessarily been able to confirm that with her directly. It was a little bit different from the written request. But currently, given the information that I received, my request is for a full contact, no contact order to be reinstated.
And can you remind, well, and Mr. Baumhofer, maybe you're better to remind me, do you all have shared children?
No, ma'am.
Okay.
We are still married.
Are there children involved, though, is my question.
Not for
We
long,
have no
buddy.
children together.
Okay, do you already utilize a Talking Parents app?
No, ma'am. I was kind of confused by this. I was not the one who requested this be dropped. Miss Mason did. We were supposed to be able to address it in person. I was brought back in, and I just kind of told my lawyer I have no issue with this. At the time Miss Mason requested this, she had showed up across the street from 440 Long Trail where I was residing, which put me in kind of an uncomfortable position, and I was already in possession of divorce paperwork. I was waiting on a response from an individual to serve her. So I just allowed this to happen and served her the papers myself.
Okay.
I'm curious if I'm allowed to present any evidence or documentation of the situation that's been occurring in the last 3 months.
So the primary, well, let me ask this, was the divorce case filed here out of Gilpin County?
It was filed in Boulder County. It has since been dropped as a result of failure on both of our parts to complete the financial disclosure. We were not able to get that in time.
Okay. And so this case is currently set for an end of deferred on April 23rd of 2027, so it is obviously ongoing. You can certainly address me about what you'd like me to know related to the mandatory protection order and what you are asking the terms look like of the mandatory protection order, but that is really the only issue before me. I just don't want you to dig into all the divorce issues. So go ahead related to the protection order.
Well, I was just going to state, I believe this is retaliation. Miss Mason had approached me and asked if she could sublet my rental in town. I ended up agreeing to that. I have documentation. I can email you of the timeline of events. October 7th, she agreed to move in and pay rent for that. I chose to allow her to, as opposed to vacate that rental. As I have moved to October 12th, we made an agreement that she could get the remainder of the October rent for cleaning. She stated she was finished cleaning and would send me an invoice because I had an agreement with the previous subtenant that he would pay half of the cleaning needs as he had left and not managed to clean. This invoice was never provided. I have documentation on November 13th from Miss Mason claiming she's been working to try to pay me. I continually asked her, please call me. Can we figure this out? I'm paying rent on the house. You have changed the locks for this house. I no longer have a key to my own house. On November, or what was that? On December 3rd, I again reached out. She said she would call me. She did not that night. December 4th, I reached out. Her son responded. She had been trying to send me money. I said, at this point, you've been living there for 3 months. I've asked the police. They've told me I need to file an eviction process. I posted a demand for compliance December 10th. Did receive no more until Miss Mason reached out December 30th at 10 o'clock. I see here from this documentation, she electronically filed this at 10:47 after requesting to go over to 440 and get a cast iron pan and return the mattresses I had provided for her to use staying at 440 or 399. I returned home. She had taken her pan. She had not returned the mattresses. I again reached out December 30th, provided a breakdown of numbers, and again stated, look, I need an invoice. Have not gotten an invoice. She stated that apparently she didn't owe me any money. She had worked it all off. This is in contradiction to the text that I can send you, this timeline, and these texts from Ms. Mason from the October 12th text where she said, add it to the money I owe you, the November 3rd text where she said, I'm working on getting you money, and the December 4th text from her son, which said she had attempted to pay me first and last month's rent. January 8th, she again reached out, sending me numbers that apparently it was 52 hours, 3 people to clean 194 square feet. I had only allowed her to clean it so that she could move in there, as I had the former tenant's cleaner set up by him. She didn't have a key because my former tenant had the key to give the cleaner because he was going to pay half, I was going to pay half. We all agreed that Miss Mason could do that so that she could move in because she was trying to get away at that time from Mr. Damien. January 8th, she gave me those numbers. I said, that's factually incorrect. That's not what you have stated. Perhaps got a little testy with my words. I came into Netherlands January 8th to see my 1988 Dodge Power Wagon had been towed into West 3rd Street, completely without care. I still don't know if there's damages. I called BC, sitting in the parking lot with a third party I had requested to come over with me. They stated she was allowed to do that in an attempt to recover her trailer, which is her property. The trailer in question I purchased 2 years ago. I let her take it when I discovered that she was cheating on me with Damien from her oldest son, who is now back in Alabama, who I was employing and allowing to stay with me.
So it sounds like there are property issues that you need to get a domestic relations case filed about.
I have no problem with going no contact with Miss Mason. I am currently in a situation where I'm told I will be arrested if I go to town. I discovered when I went to Bible study this Wednesday that the police were going to tow my car, impound it, and ticket me. I had not put it there. Miss Mason had. They had given her permission to do that. Luckily, I had a friend see the police officer there, the same individual who had called in that listened to this conversation. The on-duty police officer, I can provide his name for you because I requested that from my friend, said he would move it, and that there is no police report filed from my 45-minute conversation from Boulder County about my truck being towed. So I am happy to sign and have this be done. I am aware that this is a civil issue that I will need to file eviction for. My question to the court is, to me, this seems like retaliation. After refusing to pay rent, she is now squatting officially, refusing to pay anything because the police officers have said, if I let her in there, it's technically her residence now until I can get an eviction notice.
Do you have any concerns at this point, moving forward with the eviction? Not with the idea of not having direct communication with her about that process or the financials of it?
No, ma'am, not at all. I'm more concerned with who's holding this woman accountable. I believe she's on probation. If you look back into the case numbers, I'm one of the stated victims of court case. I'll have to look this up real quick. I'm sorry, ma'am.
That's okay. And you had filed your divorce in Boulder County
Boulder
because that's
County. I will
where
have
he
to
was
file it
residing.
again. That's where we were married, was Boulder County.
So I can't give you legal advice, but that is not the only basis for jurisdiction or where you can file.
I could file it here.
If people are residing, you can file in the place where the respondent is residing. So if you're filing and serving her, you can file it in the county in which she resides.
Okay.
It doesn't have to be Boulder, whatever, and that's up to you. I'll let you take care of that. But certainly a lot of what you're raising are issues related to division of, it sounds like, property and assets and things that need to be addressed through the divorce court. So for purposes of this case, I'm going to re-enter the mandatory protection order to order no contact. So to reiterate what that means, you cannot harass, molest, intimidate, retaliate against her. You have to vacate her home and stay away from any location she's likely to be found. That includes where you believe she to be living, regardless of, how it's titled or who owns it. You can't contact her directly or indirectly, so you will not any longer be able to have text communication or anything like that. If she texts you, you simply cannot respond. Do you understand what's required?
I do, ma'am.
Right. All other provisions, no firearms, ammunition, no drugs or alcohol, all remain in effect. I have no indication that there are concerns on probation, so I'll just order you to continue doing what you are doing as a part of your stipulation for your deferred. And then if you can hang tight a minute for us to get the protection order reissued so you can sign that. And then you'll just remain on your deferred, okay?
It'll actually be over at the clerk's office.
Oh, that's where it'll reissue. So give it a minute and then stop by the window on the way out and they'll have you sign the new order.
All right.
Okay?
Can I just clarify, will this information that I presented, will this be shared with her PO or is this just a
No.
protection order?
Yeah, it's just related to the protection order. And so the minute order will just reflect that she has requested a reversion to the no contact. You don't object to going to no contact, and I can ask that the minute order reflect for reasons you outlined.
Can I
but-
ask one final question?
Sure.
I'm guessing I have to file my own request to modify the protection order I had dropped 2 years ago, as she is still on probation for that case. The only reason I dropped that was to be able to have a divorce, the same reason that I allowed her to drop this in this case. So,
Yes, you'll have to address any protection order where you were a protected party in the case where it issued.
So they're married. So I don't know if it's community property because they're married, but he just said to the judge that he allowed her to drop the protection order in this case. I don't know about this guy. I don't know about this case. Everything he said is weird. I mean, it just doesn't make 100% sense.
and do I
Yes,
have to
okay.
do that in Boulder County because the case happened in Boulder County?
Yeah, so it looks like I see. Yeah, it looks like 23 CR 2132 out of Boulder.
Yes, ma'am.
The only issue will be whether the case is still open in terms of whether she's still serving any part of her sentence. And I can't tell that, but
She's
you can
in
contact the
jail,
Boulder
but
court
she's
to see
living
if
there.
she's still serving her sentence, then yes, you would address any request
Probation.
to modify that protection order there.
It looks like she still is.
Okay.
And then my final question is, it would not be perceived as retaliation on my part to file the civil court for eviction.
So I can't give you legal advice about how it's going to be perceived, but you know, if you are a landlord and you have somebody who you believe is not compliant, then you can proceed with an eviction case wherever. So that is obviously separate and apart from this. So you can stop by the window, sign the modified
Plot
protection
twist.
order. Good luck to
She
you.
gets the
Thank you,
house
ma'am.
in the
Thank you.
divorce.
So,
All right, and then
I don't know what's going to happen with that. It all
that-
sounded jagged and weird. I don't know. A couple things he said didn't, I don't know. It just doesn't fit right. He wasn't supposed to say any of that. She had filed with the court that she wants to reinstate a protection order. And he brought up landlord-tenant stuff and all this stuff, and they're getting a divorce. I don't know. We're going to move out of Colorado. I don't even know what we're going to do, guys. Let's go. I think we're going to Indiana. Let's see.
Real agent and
Yeah.
not Mr. Alatar.
We're going to Judge Fish. I love Judge Fish. He's so good.
That's the only reason the case is set for our hearing this morning, as far as I know.
Yeah, I agree. I had received the motion. I'll let you present that here in a minute, counsel.
That's Mr. Shargaloff. Down below. This way. Nope, this way. That's Mr. Shargaloff. We see Mr. Shargaloff a lot in Michael Cristofino's courtroom, but lately he's been popping up in everybody else's courtroom in Indiana.
Mr. Shargaloff, did you have any word about your client? He was on at the 10 o'clock setting.
And he was, Judge. I advised him that this matter was set for 11 o'clock. I am en route, Judge. I got caught up in Knox, but I'm about 10 minutes away. We did the motion I was going to make to the court today. We've recently received some information that my client was at a detox facility at the time of his last hearing. In a showing of good faith to the state, they had tendered an offer previously, Judge. We did file a signed copy of that along with a waiver of appearance on behalf of Mr. Alatar. And I would represent to the court as well, a component of that plea requires a substantial amount of restitution to be paid. I would represent to the court that we do have $4,000 now in our trust account to pay that, at least a substantial portion of that restitution figure. I believe the approximate balance is $204. So the request I was going to make to the court today, if my client was present, obviously, would be to ask the court to consider recalling that warrant and allow us to proceed forward with a change of plea.
Okay, yeah, well, he's not really shown himself to be somebody I feel like I should recall a warrant on, given that he didn't even come back on the line when he knew that we were going to be set at 11, and I told him that specifically. So I can't get with that program. I'll deny that, but certainly he could turn himself into the jail and we could deal with the situation. You know the best days for him to turn himself into the jail, Mr. Shargaloff. But I also
Understood.
have a motion for exoneration and release from surety bail bond that was filed by Mr. Stigler. I'm going to let him present that, sir. Sir, the microphone's right there. It's pointed away from you. If you want to stand at the podium, please. Thank you, sir.
Judge, it's a typical motion for exoneration that we filed. And I take that back. This one is not typical because we knew that Mr. Alatar had gotten arrested. And we had difficulty trying to find the underlying case when we searched the Wake County, North Carolina judicial records site. Last night, we were presented information that what happened was that they had spelled his name wrong. They had him in their court in 2022 and had used that misspelling for him. He's charged with cocaine possession, marijuana possession. There was a court appearance on November the 10th. He failed to appear. And if I'm looking at the docket right, that's what I filed this morning. If I'm looking at the docket right, then there is an order for his arrest that was issued in December. And my client, the bail bonds agent, did not act in any way in agreement with Mr. Alatar to commit any kind of crime. And so we are asking that the bail agent and his principals be exonerated from this particular surety bond.
State, do you have any position on this?
Thank you, Your Honor. It's been a while since I've reviewed the applicable statutes relating to the posting of surety bonds, but I believe that once notice has been received that the defendant has failed to appear, the responsibility of the bail agent is to produce the defendant within 365 days. 365 days has not elapsed, and therefore I think the motion may be premature. And whatever the contract is between the defendant and the bonding company, It's the assurance of the bonding company that they will produce the defendant in the event that he fails to appear. Otherwise, they stand to forfeit the amount of the bond that was posted, which honestly, I do not recall at this moment, but I'm going to say it's maybe $1,000 was the premium, so $10,000 was the bond. So as I said, I believe, without looking further, I think the motion may be premature since they have not produced him.
Do you want to weigh in, Mr. Shuggleoff?
Not as it relates to the issue of the exoneration, Your Honor. I do believe my client is logged on.
You believe what?
He is logged
Oh, I
on.
see. Yeah, okay, let me admit him. I see. Ubiquitous iPhone login. Mr. Alatar, can you hear us okay?
Yes, sir. Yeah, Your Honor.
Okay, where are you located, sir?
North Carolina, sir.
What address?
Sorry, that's my old address. Sorry. It's gonna be
How do you spell it?
Field. You want me to spell?
Field?
Broadlands, Your Honor.
I'm just trying to pull it out so I don't make a mistake.
Still sounds like gibberish to me, even when you say it, Mr. Shuggleoff. What's the word? Can you spell it for me?
Yeah. All right. So it would be Fields of Broadlands. Broadlands.
Broadlands.
Yes, sir.
I see.
I might have been saying it wrong. I apologize.
Okay. Yeah, your lawyer asked me to take away the bench warrant that's on you in this case. I told him I'm not going to do that. I told him you need to turn yourself in here at the Porter County Jail. So you can talk with your attorney about the best time for you to do that. That would be least disruptive to your situation. And I'm happy to work with whatever he helps you decide to do under that circumstance. And then Mr. Shargoloff also is aware he can work with the state. In any event, I heard Mr. Shargoloff indicate he's not interested in adding any additional argument related to the bond question. Mr. Stigler, did you have further support for your motion, sir?
Yes, Judge. Judge, the statutes that I cited in my motion are the statutes that permit the surety to come into court and ask for the exoneration. There is no requirement, contrary to the assertion of the prosecutor, that you can only ask for exoneration after someone has been brought before the court. That's simply not the law, Judge.
Okay, anything else, sir?
No, Judge.
All right, so we'll deny the motion for exoneration from surety bond as well. And we've got a warrant out for Mr. Alatar's arrest. Once we have him in custody, we'll get this matter back on the docket. All
Hey,
right,
Judge.
we're adjourned.
Thank you, Judge. Thank you, Judge. Michael Fish. And I think this is Frederico. I can't remember his name. No, it's not. Okay. This is Judge something. I can't remember, and I can't read that right now. But if you look, okay, there's another judge. This is Mika Cox. Okay. This is Judge Kim's courtroom. We watch Judge Kim rarely. He doesn't stream often. And he is excellent. He's so good. But it looks like Judge Cox is in Judge Kim's courtroom today. Which, I thought it was pretty cool seeing a different judge in his courtroom.
He's got his ride is here. I don't know. 75 C01 2511 F6 172, State of Indiana versus James Napier. Mr. Napier, where you at? All right. Napier's in person in custody. I guess some of the other counties here to transport you, sir. I don't know. Mr. Shargoloff appears representing Mr. Napier in the state by Attorney Baker. Mr. Shargoloff, what do you want to say about Mr. Napier?
Your Honor, we had submitted a plea for the court's consideration in this case. I know it's slightly odd. Just to recap on behalf of Mr. Napier, there was some issues regarding the contacting the victim in this case. I certainly don't want to speak for the state, but I think that from both sides, my office attempted to contact, I believe the state attempted to contact as well. So the uniqueness of the plea is based on what I would suggest would be some evidentiary issues. This is, we believe, in light of those circumstances, fair and reasonable.
Okay, so I mean, essentially, this is, the state can't prove the felony, so we're pleading him to a misdemeanor. Is that what this is?
2 misdemeanors, Your Honor, based on the facts and circumstances of the case.
Okay. All right,
you guys got to pay attention about how he handles this paperwork. I have never seen a more laid back, I do not give a crap about my job judge. He's awesome.
okay, is that what you want to do, Mr. Napier? All right. So here we go. Raise your right hand. Do you swear or affirm under the pains and penalties of perjury any testimony you give today will be the truth? State your full name for the record.
David.
Are you under the influence of any drugs, narcotics, or alcohol today?
No.
Are you taking anything that would impair your ability to understand what we're doing right now? All right. So what this plea agreement says is you're going to plead guilty to 2 counts. Why, I don't know, but count 5 and count 6, they're both class B misdemeanors. Count 5 is disorderly conduct. Count 6 is public intoxication. In exchange for your plea of guilty of those 2 offenses, you'd receive a time served sentence in both counts. They would both run concurrently. You want them to pay 2 alcohol countermeasure fees, one for each count? I think
There was one, Your Honor, so
that's in both counts, but that's what I'm. But, yeah, I'm just gonna, okay. Yeah, I'm not sure you could do it per count. I think it's based on cost numbers. All right. So let's look at this. So you're gonna pay an alcohol countermeasure fee, court costs. Those costs will be made in judgment. The parties agree you have 59 actual days to credit. I'm gonna give a DNA swab on a misdemeanor. Take that out too. So basically, it's time served, they're running concurrent, you're gonna court costs and alcohol measure fee, and any other counts are dismissed. Is that what you want to do, sir?
yes.
All right. So you understand that means today I'm gonna enter a judgment of conviction and I'm gonna sentence you without a trial? Do you understand if we go forward and do this today, that means I'm gonna sentence you and enter a judgment of conviction, there will be no trial. Do you understand that? That means you're going to waive or give up your right to a speedy public trial before a judge or a jury, waive or give up your right to see the evidence, face the witnesses, confront and cross-examine those witnesses, waive or give up your right to use the court's compulsory process or subpoena power, waive or give up your right to remain silent, meaning you cannot be compelled to testify against yourself. Most importantly, if I haven't said this already, no conviction can be entered against you unless the state can prove it beyond a reasonable doubt with legally admissible evidence to a unanimous jury. And you're also waiving or giving up your right to appeal and the appointment of an attorney to conduct that appeal if you're indigent pursuant to the terms of this agreement. What you're going to have to tell me you did do and establish conclusively here is as follows: disorderly conduct, count 5, that on or about November 16th, 2025 in the county of Stark, state of Indiana. James Napier did recklessly, knowingly, or intentionally engage in fighting or tumultuous conduct. And then 6, public intoxication. On about that same date, you were found at the above location, not sure where that is, in a state of intoxication caused by the person's use of alcohol or controlled substance. I don't have the last page. I assume what's the other part? It's almost tore the last page off of my information.
He's under danger to himself.
Endanger yourself. All right. Endanger yourself or
Or
others.
limited danger of breaching the public restriction.
All right. So you understand that that's what you're getting ready to admit to, sir?
Yeah.
Okay. All right. Do you have any questions about anything or the nature of the agreement? Let me skip over all this stuff here. Hang on a second. Do you have any prior misdemeanor convictions? Really?
There's a pending case in Porter Superior 1, Your Honor.
Okay, is it a felony?
Yes.
Okay. Do you have prior felony convictions, sir? That one? Yeah, okay.
And I think maybe
All right. Prior juvenile adjudications? No. You understand that any prior history you have could be a reason I reject the plea?
I don't know. Okay.
Sure. Were you on parole or probation at the time of this offense?
Be trial release.
Right, so that's the second part I'm getting to. So you were out on another offense when you committed this offense, right?
Well, I wasn't sentenced on it.
Right, it was pretrial. I understand that. Do you understand that since you were out on that other case, if you plead guilty here, one, it could require that other sentence be consecutive to this one if you're ever convicted, and two, it could be used as a basis to revoke your release in the other case.
Yeah, you want to know that.
Okay. Other than that case and this case, you have any other cases pending?
Oh.
All right. Well, this isn't a felony, so I ain't even gonna tell you that. So with all these rights in mind and potential penalties, you still want to plead guilty?
Yeah.
You think this plea agreement's in your best interest? Has anyone threatened you or forced you to get your plea guilty? Anyone given anything of value or promised you anything outside this agreement to get you to plead guilty?
No.
You're satisfied with Mr. Chargaloff as your attorney?
Yes.
All right, so let's go ahead and go forward with the factual basis. Go ahead, Mr. Chargaloff.
Thank you. Mr. Napier, I'd like to direct your attention back to November 17th of 2025. At that time, were you present here in Stark County, Indiana? Yes. All right. And at that time, you agreed that you were engaged in tumultuous conduct. There was a verbal altercation you had with the person alleged to be victim one, correct? Yeah, yeah. All right. And furthermore, there was an interaction you had with some law enforcement officers where your voice was raised to the level of tumultuous conduct, correct? Now, we're not talking, Mr. Napier, about whether or not they should have been there or the like, but you got into a verbal altercation with them, correct? Pardon me? Raise my voice. But I'm sad here, I have to say that. You engaged in a verbal altercation, all right? Yeah. Okay. And again, this occurred within Stark County, state of Indiana. Yes. All right. Now, at the time, at some point in time, Mr. Napier, in this interaction with law enforcement, prior to that interaction, you had consumed alcohol, correct? Yes, and they know that. Okay. Now, regardless of the circumstances, you then were removed from the house, correct? Yes. Okay. Now, when you were removed, hold on, Mr. Napier. When you were removed from the house, you were in a public area, correct? No, I wasn't. Yeah. What are you saying? I mean, no.
Mr. Napier, do you want to talk to Mr. Chargaloff, maybe?
But yes, I was in a public area. I was standing in my door. Okay. May I continue, Judge, or should I take a moment, Mr. Napier? Let's keep continuing. I'm gonna go ahead and plead guilty to this.
I don't know if his door is a public area, but.
Well,
Could have a moment. Yeah.
Out of my.
Sir, just hang on a second. I think you're misunderstanding what Mr. Chargaloff's trying to ask you.
No, I know what he's at. I don't agree with him. Doesn't mean much.
Right, I don't know if they're.
Let's just go ahead and plead guilty to this, get this over with. I've done it, guilty. I was in a public area, down in the yard. All that. No good. So. Right, already here. Now. Back in, Your Honor.
Yeah, go ahead.
All right. So, Mr. Napier, going back to that same date, you would agree that you appeared in a public place in a state of intoxication that presented a potential danger to either yourself or you were in imminent danger of breaching the peace. Is that correct? Yes, I was. Right, and that also occurred within Stark County, state of Indiana. Yes, it did. All right, nothing further, Your Honor. I believe that satisfies the factual basis as it relates to the two pled counts. Defense would further stipulate to the probable cause affidavit only as it relates to the two pled counts.
All right, state. All right, so Mr. Napier, you're telling me that you committed these offenses because you're guilty, right?
Yes.
All right. Mr. Shargaloff, you know any reason why I shouldn't accept his admission?
Your Honor, given the circumstances, I do not.
All right, sir.
Just for purposes of the record, I do not see a reason to go forward with trial, given the terms of the plea agreement.
I understand. Sir, I'm going to find you understand your rights, the potential penalties, and the nature of the charge. Is that all in fact true?
Yes.
I'm going to find you knowingly and voluntarily waive those rights and enter this plea agreement. Is that also true?
Yes.
If I haven't said so already, I'm finding a factual basis for those two counts. I would point out the plea has them, I think, in this body where the terms are as count 1 and 2, but they're actually count 5 and 6. So we're just going to make that adjustment so they're numbered properly. Any argument the state wants to make it sentencing? Mr. Shargaloff?
Just ask court to accept the plea as tendered, Your Honor.
Mr. Shargaloff, or I'm sorry, Mr. Napier, I don't know what Mr. Shargaloff said about your opportunity to say whatever you want to say here, but now's your opportunity to take it. If you want to take it, you don't have to take it.
I ain't got nothing to say.
Okay. So I'm going to accept your plea. I'm going to sentence you pursuant to its terms. So it's essentially a time served sentence, and there was already a discussion here on the record about why this is the way it is. You've been in custody for 59 actual days. You get day for day credit. So, I mean, that's a good amount of time on Class B misdemeanors. They run concurrent. Any other counts are dismissed at sentencing. If there was a no contact order or anything, that's vacated. You're going to owe a balance here at the courthouse, sir, for this alcohol countermeasure fee and court costs. That's something I guess you can pay on, but it sounds like you're going to get transported to another county. You have any questions?
No, sir.
State, anything else?
No, Your Honor, thank you.
Mr. Shargaloff?
No, Your Honor.
Good luck, sir.
Yep.
Good
Does he
luck.
need to,
Good luck, sir.
Okay, they're
I don't even have the rest of the pages to this, guys. Where's the other pages? Don't worry about it. We're just going to go forward. He almost messed up his plea. But Mr. Shargaloff, who was with Mr. Fish, or Judge Fish, who we often see with Judge Cristofino, fixed it. Good job, Mr. Shargaloff. Way to go. And you can tell this is a different day because he's not in that tan suit. All right, guys. Thank you so much for coming out. I really appreciate it. I do. I have my stream set up for Wednesday night. That's tomorrow. Tomorrow night. I'll still stream tomorrow morning. Don't worry. I just don't have anything ready for that yet. But it's not time for that. It's time for OJ. We are I think we're on September 19th of the OJ Simpson murder trial. And the last day is October 3rd, 1995, of the O.J. Simpson trial. That's how close we are to the end. And because we are so close to the end, it is extra annoying to watch these damn lawyers ask these stupid questions over and over and over again that mean absolutely nothing. So we're going to talk about EDTA and gene imprints and shoe imprints for the next 2 hours, and it's going to be great. Hopefully we get a sanction. See you in a couple minutes, guys. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time.